Thanks for coming tonight. First, I would like to acknowledge the traditional owners of the country on which we meet today, the Gadigal people of the Eora Nation, the traditional custodians of this land, and pay my respect to the elders, both past and present. So, as I said, welcome everyone to it's our first Q&A panel. It's our first event. We've been talking about doing events for a while, and we finally put one together. So, hopefully, we're aiming to fill the auditorium the next time. So, hopefully, we'll see you all back again. But we're here to have a chat about the recent Folau, Israel Folau and Michaela Banerji cases that most of you will have seen in the media. The one thing that we all will be very well aware of is you don't have to be in the public eye. You don't have to be an athlete to have these issues affect you. So anyone here or everyone here will be governed by, an employment contract. You'll have codes of conduct. You'll have policies. So you can find yourself in all sorts of hot water because you may have said something on social media. And the other things that we've seen from these cases, and we'll hear a bit more about tonight, is that it may not even matter whether you're posting or you're liking or sharing from your own personal social media accounts. So these cases are even raising questions around whether there is even any difference between a public or a private social media account anymore. So we have, on the one hand, the High Court case of Michaela Banerji. And Michaela was a public servant working for the Department of Immigration. She was employed there in 2009. I think that was the year that the iPhone was invented, so very, very early on. Michaela decided to start an anonymous Twitter handle, a very early adopter, under the pseudonym La Legal. She was subsequently fired for the comments that were posted on her anonymous account. On the other hand, we have Israel Folau, who is, we all know, a high-profile professional rugby player, and he was sacked earlier this year after failing to heed Rugby Australia's warnings about the content that he was posting on his social media accounts. And Folau is currently suing Rugby Australia for unlawful termination, including on the grounds of that it impinged on his religious freedoms. And I think the case is due to be, the hearing will be in December, 17th of December, if the mediation doesn't resolve the problems. So I'm going to turn it over to our panel. We do have an incredible panel tonight, so there should be a lot of interesting discussion. And I would like to also introduce our moderator for the evening. He's someone called you a ringmaster just before, Peter Ryan. Peter is the Senior Business Correspondent for ABC News. We have on our panel Annabelle Williams, OAM. Annabelle is a Paralympic gold medalist. She's the Vice President of the Paralympic Olympic Committee and on about 8 other committees, I understand, which I won't list all tonight because it would take a while to go through. But Annabelle's also a diversity advocate, and she was a former legal counsel for the Australian Olympic Committee. We also have Eleni North. Eleni is the General Counsel of the NRL, so I'm sure that she'll have some interesting insights. And we have Mandy Galms. Mandy Galms is the CEO of Hill & Knowlton, which is one of the world's, am I right, largest PR and comms company? Sounds great. That's who you are tonight. We then have Danny King. Danny is a employment law specialist, and she's the founder and the principal of Danny King Legal. And then we have Rob Arnold, who insisted on sitting at the end. But Rob is our international, you're our Tour de France commentator. And he's also the founder and publisher of Ride Media. So from a journalist perspective, and with lots of experience in having seen what happens on an international level as well. So I'm going to hand it over to Peter now, and he will lead the charge.
Okay. Well, hi everyone. Thanks, Sarah. Thanks for the opportunity of being able to be here today with such a great panel. and great future contacts for me as well, given that social media really gets involved in just about any stories that I'm involved with at the ABC, whether that's business, economics, finance, technology, sport, the law. It's all surrounding social media these days. If I'm doing a story on the AM program or PM or something like that, I'm always tweeting out my stories, although very aware about tweeting in a professional manner and perhaps being more conservative than I might be about any personal comments or views or commentary. I might leave that for Instagram or Facebook, but that's probably another story. A number of years ago, when I came back after a long stint from the United States at the ABC, I met a number of people who are involved in issues management, crisis management, media training, and part of some of the early media training involved advising clients and potential clients that you better watch what you say when you're being interviewed at the newspaper, radio or TV, because particularly in the newspaper, your comments may end up sitting in a dentist or doctor's surgery for the next 20 or 30 years. Now, that's the equivalent now, that when people say something on social media, whether it's Facebook or Twitter, Instagram, it's going to stay there for a long time, and most people know it's very difficult to retract anything like that, as we've seen with some of the issues after the Christchurch massacre of trying to sort of unwind things after everything's out there. So what we'd like to do today is get to the issues, and if you look at the last few years, particularly, I have a daughter who's 18 and lives a life through monitoring celebrities and influencers, publicising their views of whether they're the Kardashians or not. This comes from their own social media accounts, but often these people like Bono, George Clooney, Angelina Jolie, they're tracked as being more effective in getting media coverage for their pet causes than, I understand, sitting US presidents or members of Congress, and I suppose that's the star factor. But I think just really opening this up here, if we can just get to the panel, I mean, what do we think about celebrities using social media to advocate on their own behalf, whether that's serious social or political issues, or getting into those things like climate change or the Me Too movement? Elaine, maybe you might like to start us off with that. What are your views about celebrities using social media?
Look, I obviously think it depends on the context, being a lawyer, but I was listening to someone speaking the other day. It was actually Dani Minogue, who I guess is a celebrity, and one of the things she was saying is she absolutely loves social media because it gives her an opportunity to have a voice, where previously the media was able to portray her in whichever manner they wish to do so, but social media gives her a voice. And so if you think of social media in the sense of, obviously we understand why celebrities who have reach and they have access to people and they have the ability to influence, and it provides a platform to do that. And so if you think of social media from a positive sense, we're going to speak tonight about, I think, some sort of negative aspects of social media perhaps, but if you think of social media from a positive perspective, it provides people with a voice, and yes, they may get it wrong, but if you sort of think of social media as a free market, then there's plenty of people telling them that they've got it wrong as well. And so I think social media serves a positive, it has a positive purpose in allowing people to have a voice, and it obviously can be used for good and bad, but...
We've seen some big issues, of course, with Israel Folau, with the ARU. What about the NRL? What's the social media policy there? I mean, how do you deal with that? Because, you
Sure.
could have, footy players, stars, out jumping on particular issues, being quite serious about it to other extremes.
Yep. So the first thing I'll say is it's no surprise to me that this episode involving Israel Folau, or this question that has arisen in the context of sport. Sport is quite often a platform that these issues which are at the forefront of the law come to bear, and that's for a number of reasons. But in this context, I think, first of all, there is a group of young people who are digital natives who have something to say, and people want to hear what they've got to say. So that's the first thing we've got with sport and with the NRL and any sport. Secondly, we've got an environment in which sports rely on creating an association with their fans and with brands. And so sports rely on their reputations, and so commentary in connection with the sport is important. Thirdly, and this is something that I think people outside of sport don't always think about, and it's something that Annabelle would be very familiar with, but sports such as the NRL and Rugby Australia and the AOC are also regulatory bodies, and they have their own regulatory systems. And so the NRL has had in place, as part of its rules that regulate the conduct of players off-field, a rule that talks about the importance of social media, the comments that are made on social media, and the comments made in social media cannot vilify people. They can't be offensive. They can't discriminate or affect the reputation of the game. And so that rule has existed for a long time. The regulatory system in relation to Rugby Australia, I'm not going to comment on it, I don't understand it, but sports have these things in place, and so all of these factors together mean that it's right for these issues to come to the forefront.
I was going to follow that up with Annabelle, because politicians, CEOs, chairmen, boards have media managers, teams of PR advisors. But what about sports people? Because it used to be the case where if you're a footy player or an athlete, you pretty much learnt on the job. But that's clearly not the case these days.
No, so to give you, I feel like I can come at this from a number of different angles. I was an athlete, and an athlete at the very beginning of social media, and was on teams with a number of very high-profile athletes who made mistakes. Probably the most prominent one was Stephanie Rice, the swimmer who made a homophobic tweet. I think it was 2009 maybe, when Australia played South Africa in a rugby match, and the fallout from that was very, very public and incredibly damaging for her. I've also, until recently, been the legal counsel for the Australian Olympic Committee, and so as in a similar way to the NRL, the AOC has social media policies and frameworks around what athletes can and can't do. And then I'm also the chair, I'm on the board of the Paralympics Australia, but I'm also the chair of their Athletes Commission and the deputy chair of the Australian Swimmers Association. So we sort of work with the national federations and the Paralympics Australia to manage athletes' social media. So yes, I feel like now I've forgotten the original part of the question. So the training.
So people, learning about social media on the job, or do you advise them very strongly to be careful about what they're saying?
The AOC is in this funny position where we only the AOC only has the athletes for really a month every 4 years. They're not contractually bound to us outside that period. So it's really the national federations that take control of that more often. And I know Swimming Australia, it's been a really large focus of theirs. Also because social media has the tendency to really distract athletes. Emily Seebohm, one of the swimmers, spoke very openly about how it distracted her terribly during the Rio Games. And so on the Swimmers Association, we also work with athletes to make sure they're managing their social media appropriately during competition. So there is more training these days for sure, but I do sometimes feel like and I've thought this since the beginning of social media, it can be incredibly damaging. Athletes were sort of held in this high and mighty regard for many, many years prior to social media. And then as soon as social media started, there was literally no filter between the athlete and the entire world. And so in some ways it's been very good, and it's meant that the athletes have had more sponsorship opportunities and all sorts of things. But on the other hand, there have been instances where it's been very damaging.
And is it the case that you've got sports managers, consultants, media trainers, other special advisors who go through social media trying to scrub any of those type of comments or pictures? Do we have any thoughts on that?
I can't. Thank you. I think what I can say is it's trying to catch the issue before it becomes an issue, right? So you want to make sure that whoever you're working with, whether it's your players or whether your association, are really, really clear from the outset about what they can say and what they can't say, and where the boundaries are between using their personal brand as a way to tell that personal story or connect with their fans versus their obligations as a brand representative or an employee of that organisation. And I think, that's where the tension really lies, is that fine line between your personal brand and your obligations as an athlete or employer to the bigger body or the bigger, team that employs you. And I think the Israel Folau case is a really, obviously a case in point where his personal views really conflicted with the ideology and the cultural position that rugby league had very publicly come out with and was very publicly forcing a whole lot of cultural change around.
And look, just while we're speaking about Israel Folau, that pretty much boiled down to being a contractual issue, right? So is there any grey area there where Israel's able to, stand up and fight that, saying that he still had free speech despite having, put his name to, that contract?
Danny, I'll hand over to you.
Look, personally, I don't think so. If you are paid, and very handsomely at that, to be an employee of a particular organisation, you're doing that subject to a bunch of terms and conditions. And you don't have to be an employee of that organisation, but they're purchasing from you a whole range of things. It's not just what you do 9 to 5. And the purchase is an exchange of loyalty. You've got to put your employer's interests over your own, otherwise it's a conflict. And so if there is a request/demand that you behave in a certain way, then the employer is entitled to expect that you will, and there'll be consequences if you don't. And Rugby Australia tried very hard to help Israel Folau to make a better choice, and he did it again. So I just don't see that there's wriggle room there.
And it's not just employees, but what about employers? Are they exposed, for example, if someone uses a company's systems to make, for example, homophobic comments or inappropriate comments on social media?
The fallout for Rugby Australia on a commercial basis is one thing, and we all know about the loss of sponsorship opportunities, but what about their employees who identify as one of the things that Israel Folau listed as being someone going to hell? As a woman married to a woman with children, I'm thinking, you know what? I'm going to think about what I say before I say it on a panel.
So, if employers are potentially exposed, I mean, and I suppose it's probably fair to say we're not exactly in the infancy of social media or the use of systems, but if an employer doesn't properly inform staff about appropriate use, could they end up facing legal action?
There are some legal principles in discrimination law and vicarious liability about the ability to say we did everything we possibly could to stop sexual harassment in particular from occurring, and accordingly the liability sits with the harasser and it shouldn't come up and bite us. Training, having policies, these are the sorts of things that employers can use to try and distance themselves from the fallout of certain conduct, but ultimately you've got to do quite a lot to be able to avoid vicarious liability. And if you're a person aggrieved and you're looking to sue someone, you want to sue the employer because that's where the money normally is. The harasser probably has a car that you can claim. So the economic incentive is there to go after the employer in any case, and they're becoming more and more accountable for the actions of their employees as well.
And Rob, what do you see as the big risks when it comes to sports people, not just rugby league players or but say in Tour de France, in other more elite sports, there's the risk there as well, isn't there?
I can't comment on rugby league at all, unfortunately. I don't watch the game, but I know that social media has had a big impact on cycling. I think Lance Armstrong, who won the Tour and then lost the Tour de France 7 times, he's an anomaly case. He introduced me to Twitter. I didn't know about it until 2008 when he made his comeback to racing. And since then, he's exploited that to the best of his ability, even in the massive downfall that came about with his confession at the beginning of 2013. And so he had built an audience, amassed a fortune based on his popularity, and also gave himself a voice. And then that came back to bite him. But ultimately, the sycophant crowd has enormous sway on social media, and we see that even now he was vilified and he was put up as the poster child of doping in a world that's rampant with doping, and it got to the point where he was parodying himself in movies and so on, and yet he instead of running for the hills and trying to seek anonymity, he's come back at it and actually accelerated his public persona by creating a podcast and building a media audience. So his retribution for all of the vilification he received was to use social media to gain again and build an even greater platform than he had, because as an athlete his career was limited, but now that he's become let's say a media personality, although I say it in quote marks because I refuse to listen to the podcast, but he has a huge audience, and it's all through social media. So I'm watching an impact of social media, and it's largely just the Twitter platform.
And we've seen this, through cases where, athletes, for example, have, used their, I suppose, indiscretions or potential indiscretions as soul-bearing opportunities to actually get out there and to get on the front foot and to hopefully, clean their own slate. But as you're saying, the case of Lance Armstrong's created another industry out of it.
Well, he's used it to his advantage. He's a very savvy character. He knows what he's doing, and he was better at many things, not just riding a bike. But we've seen other examples of athletes managing it completely appallingly, and generally they opt for silence. Bradley Wiggins is another Tour de France champion who's been vilified recently, again because of doping allegations, and his immediate response is, like everyone, just to remain silent and offer no opinion and let the speculation die out. And what did he do? He likewise came back and became part of the media, and he's now on the back of a motorcycle calling the Tour de France, and is receiving accolades because he's basically couldn't care less, and he's actually thumbing his nose at the basic commentary protocols. And we can see more or less a debasing of what had once been a clever, considered commentary, but it's going to be popular because he's being humorous. He's on the back of a motorbike having fun, talking about the crazy French and mocking the infatuation with Chateau during a sporting event, and people love it. And so instead of getting information, we're getting wit and humour, and that can be good and it can be bad. And in the sporting sense, it is ultimately entertainment, so it needs to have a sense of humour. But when there's money involved, then you run the risk of turning that humour into a liability, and it won't be long before Armstrong or Wiggins or whoever the other name may be comes up and makes a huge faux pas. And I don't know if it's going to be at the extent of Folau, but there is that accessibility to an enormous audience, and I guess that's what we're talking about here tonight.
And Manny, I was going to ask you about, so you have clients coming to you, you're part of a multinational PR company, dealing in issues and crisis or whatever, full service agency, but when you have clients coming to you, whether they're big players or small players or people looking for advice, are they automatically asking for advice on how to handle social media issues if they come up?
Yeah, it's absolutely part of the toolkit of what we will work with our clients around. I think a recent survey revealed that the biggest corporate risk facing business leaders today is actually reputational damage, and it's been shown to have a direct impact on shareholder value. I mean, that's how serious it is. And when you look at that reputational damage, they're really concerned about cyber attacks, and social media reputation damage falls into that cyber category. So, we're working with our clients, on a number of fronts, but it's really in that early planning stage to make sure that everyone actually considers whether or not they've got a plan in place to handle a crisis, because a crisis isn't a maybe, it's a it will happen, let's be prepared for it.
So social media is not a bolt-on to those type of strategies anymore, it's probably in the first page.
Yeah, absolutely. And I think when we're building out campaigns, we'll look at not only what are we trying to do proactively in terms of building someone's brand or building the reputation of a particular product in market, but what are the risk factors associated with that? So, if, for example, we do have an influencer or a celebrity involved, we will work with our clients to make sure that they have not said anything in their past on their social media profile that's directly in conflict with the product or the service or the industry sector that particular brand wants to, grow, evolve or launch into. So,
without naming names, have you found anything spectacularly, potentially embarrassing or an issue that you've had to communicate back to a client?
Look, I think probably one of the most challenging issues we've had to work through was we represented Banana Boat during their sunscreen crisis over the past few summers, and that's actually been quite difficult to walk with them through the different stages of reputation management from, defend, which is really about making sure that we've got a clear strategy in place about how you manage the issues as they arise. I mean, no one wants to see the picture of a sunburnt baby plastered all over social media, which then, has a flow-through effect to traditional media channels. So how do we address the issue, really make sure that we're educating, Banana Boat users how to actually use sunscreen, and then protecting further brand damage by quarantining whatever conversations we can, taking them offline wherever we can, and actually addressing that particular individual or that particular query directly. So I think there's probably three aspects of it. It's building the plan in place, and then actually having the transparency, so really speaking to your community and having the right messages to address it directly, and then empowering your community managers, who might be managing those social media channels, to actually have that voice.
And Danny, do you have similar, inquiries when people come to you looking for this sort of advice?
Yes. For our executive clients, we'll often be in the background helping the people that have been accused of some very significant and embarrassing conduct. I've had a number of clients who've been on the front page, and the kinds of services that they look into include scrubbing their public profile. They'll get someone to do it. I don't know how it happens.
We don't do that.
You will outsource that one.
Yeah. And also looking to get some PR in there to try and help stem the hate that comes, especially with the Me Too movement. If you're on the receiving end of the Me Too allegations, it's trial by media, and you either run and hide, or you stand and fight, or you try and do something in between, and it's very hard. It's very hard to fight, and it's also very hard for an employer to fight too. If you've got someone that starts to attack you, your employer brand is very exposed, and it can be quite damaging.
And Sarah, I'm not sure whether I meant to actually ask someone in the audience to mention this, but I thought I'd just move from that. There was a question that came in the lead up here about how do you field or handle private message abuse on social media. Some influencers and high-profile Australians have screenshot horrendous private messages sent to them. I've seen that, for example, at 7:30 report Lee Sales, when she's received abuse on social media. She's screenshotted that and put it out to actually call them out. But there would be ramifications in having been forced to read that and then putting it out. And I know before the age of Twitter, I used to, as an executive producer of a program, I used to look at messages that used to come in via the website that there's no way I would have passed them on to the presenter or reporters to shield them. And I refused to do so despite a few heated discussions about that. But there are ramifications these days now for sharing that type of abuse, particularly as it could be defamatory or distressing to other people who are reading.
It's hard because there are so many different obligations that overlay that. So Lee Sales would arguably be receiving those items of correspondence is a part of her role. So the ABC arguably should have taken steps to make sure that her environment was safe and free from harm, and receiving that kind of vitriolic abuse is, you know, I'm a bit of a fangirl and I know that she handles it at least publicly very well, but I personally would be devastated to receive those sorts of messages, and I would hate to think that any of my staff would be on the receiving end of even a skerrick of that kind of abuse. So I think that there is definitely a role for an employer to play in trying to help their staff, if not shield them from the bad that comes in, give them some training to help deal with how you deal with the kind of impact that comes from that.
And Annabelle, have you had experiences of that yourself, or known people who've copped that sort of abuse? How have they handled that, and how have they been made aware of the ramifications of sharing?
Well, I've seen, so I do quite a lot of commentating for the ABC, love the ABC, and Channel 7 it's for sport. And I'm fortunate that I haven't been a victim of trolling, but a number of the athletes I've presented with have been the victims of horrific trolling. And I have seen, it's like the cesspit of humanity lives on social media. Just some things that are horrendous and people should never have to see. And those particular athletes saw those comments at a point in time when they were going through they had just retired from their sport and they were dealing with athlete transition simultaneously, and it was devastating for them. And one of the, I know lots of sports are focusing on it now, on all sorts of mental health issues that athletes face when they finish sport. And for those particular athletes, it was that they decided they'd never do any sort of work in the media whatsoever again. And they chose not to share that information, but from that perspective, I've seen it have devastating consequences on athletes.
I just wanted to move on to the Banerji case, because I think that really, I mean, I've worked in the public service now for a number of decades, and as I mentioned before, I'm very careful about what I would post on social media that might move from straight reporting to analysis, and I'm wary about commentary, so I'm very careful about that. But in the case of Banerji, she thought she had the cover of being anonymous, but that doesn't cover you, because you're ultimately going to be found out, right?
If I send you some hate mail and you're my boss, and I say very hurtful, nasty things, and I think I can get away with it, and you find out it was actually me who was sending you hate mail in snail mail, you would want to sack me. How is social media any different? Well, it's bigger. So it's not just a personal message of hate, it is a global message of hate, and it's 9,000 of them. This wasn't just one or two, this was like a dedicated campaign of hate against her employer. So I think that's a pretty extreme case example, but how the High Court has considered it is very specifically tailored towards her fact situation. And in how it applies to all of us, well, it's not the kind of case that we can just say, oh, well, that now applies to all public service employees. It applies to people who are in her situation, which is actually quite narrow. But the principle about the fact that your public persona is something that your employer can hold you accountable for, particularly where they've told you that they're going to, is one that is well established. And
would there have been any grey area if she was putting out these tweets or comments on her own private hardware? Does it make any difference? It doesn't matter whether she was doing it from the office or from home.
Is it paper that she bought at the newsagent or paper that she took from the printer during the work? How does the use of particular equipment change the fact that she did what she did? I don't see that there's any difference. The impact is the same.
I would imagine in government, the social media monitoring must be huge, because I know from my experience, if I put out a story or make a comment on something, it's almost instantaneous. I've had cases where a story has been off the air for 5 minutes, and the Prime Minister's office has been on the phone. They're monitoring, and this is after I've followed up something off AM. But I was wondering, say, in the NRL, what's the social media monitoring operation there? Do you have people who are constantly monitoring, or is that something that you outsource?
We don't monitor statements that players are making, and we don't. We obviously monitor things that are coming through our own channels and our own sites, and so we have the NRL has a very large following on Facebook and other social media sites, and so we monitor the comments that come through those sites, but we don't monitor players' comments on a regular basis. In saying that, we have a large integrity unit, and their role is to consider breaches of our rules, and so if they were to see something or someone were to bring something to their attention which amounted to a breach of the rules, then that's something that would be investigated. But on a slightly different perspective, and I think it's important, is that one of the things that we have seen over the last couple of years is that we've spoken a lot today about comments that are being made on social media, but video has become a much bigger part of social media, and what we have seen is videos being used in all sorts of different ways, and part of the training that our players receive in relation to social media is not just about the way they behave on social media, but it is considering how other people around them may be taking videos of them and putting them on their social media sites, or what other people might be saying on social media, and that has been something which is quite new. But these are public people; they're known in public. If you see someone out in public, someone might take a video of you. So if you're doing something stupid, someone's going to see you, they're going to video you, and they're going to put it on social media. And so that's another way that social media permeates the lives of people in the public eye. And so our training doesn't just focus on what they're doing, but also thinking about how other people may perceive, may record what you're doing and put it on their social media channels. And so it's another dimension, and it's quite difficult to control those sorts of things.
It's very hard to wind it back once that's out.
Absolutely, yeah.
But if you look at, say, the damage from the whole Israel Folau matter, Land Rover confiscates the car. ASICS declares their relationship with Rugby Australia is untenable. Network 10 said it fully supports Rugby Australia, and Qantas is waiting to see what happens. I mean, that's big, not quite carnage, but that's a very big corporate reaction. But if, say, an employee makes comments in their own time where they believe they're speaking as individuals, do they still have that responsibility regardless of what they think?
Yes.
Right.
The cases have considered this in some detail in different contexts, but if you look at what the Fair Work Commission has said in unfair dismissal cases, dismissal will often be upheld, and so the decision that the employer made to terminate be validated, where the employee has sent a group even just to a small number of people, or their social media settings are set at the absolute highest of privacy settings, and they've only got personal friends that are friends, and they think it's safe to say things that takes their fancy. But if one of the people that is capable of seeing that post is a colleague, then that's going to impact on their employer's interests, and it's also likely to get back to the employer, because what the employer doesn't know, you can't be sacked for. But as soon as they are aware of it, that's a very good basis to consider someone's employment as untenable. Not in all cases, and get advice before you do these things, but there is no such thing as private. You should be very careful about everything that you put in writing of any form that is going to be critical of another person, especially the person that pays your mortgage.
I was about to say that you'd think people would be getting smarter about this, but I think you only just have to look on Twitter or Facebook to realise that people aren't. But
that's what I was saying in this other context. You can control some things. You can potentially control your own behaviour, but you can't necessarily control other people's behaviour. And so if you let your friend take a stupid video of you doing something really, really stupid, and you let them post it on a closed WhatsApp group, and one of those people releases that video, that can ruin your reputation. It can affect the reputation of your employer, and that person themselves may not have done anything wrong other than being stupid, but there's a lot of implications that flow from these things, and unfortunately, just because you haven't done anything yourself doesn't mean that your employer's reputation can't be impacted via social media.
And by association.
By association. So if I'm a footballer and I do something stupid and I think no one's going to see it, but then someone does see it, then by association there is an impact. So it's very difficult.
And do we have any international case studies where we've seen, whether it's via brand damage that people have lost their jobs simply by association, or being, maybe there's a separation between a particular person and an incident where people have lost their job just by, I guess, being, indirectly associated with an issue. Have we heard anything of that at all?
Oh, look, maybe, but I don't know.
Yeah. Because the other thing I'm thinking as well is there would be some employers are always looking for reasons to make decisions to let people go. Is there a case, just from the legal front, where you've heard that some employers might be, looking for any tiny reason to fire someone, and a social media indiscretion could be that?
I'm sure it happens all the time, and it's a very easy instance of gross misconduct to put up as the head reason, but we've also got a number of protections in Australian law, interestingly called the general protections, that apply to remedy decisions that are made with a substantive and operative basis of that decision being unlawful. So if it's said something stupid on social media, but also we've decided that we are going to racially profile just this particular kind of race and we don't want them working here, or we've decided that all pregnant women are just a pain in the ass, so we're going to sack them, or she's got, a workers' comp claim that we think is pretty good and we don't want her on the books. Let's use this social media as leverage. Then you can look at the timeline. When was the employer put on notice of this social media instance? Have they already discussed it? Was there a warning issued? Has it already been resolved? Because there's a bit of double jeopardy there. You can't then just pull it out and say this is the sole reason for this termination. Because even if there is a valid reason for termination, if one of the substantive and operative reasons is because of a workplace right or a protected characteristic, then that's going to be a breach of the general protections.
And I guess, we're getting into other issues. For example, as we saw last week or the week before about the NBA and their general manager Daryl Morey tweeting, "Fight for freedom, stand with Hong Kong." Now, depending on what side of the argument you're on, you might think, well, this is refreshing to see sporting organisations perhaps standing up and being independent. But of course, that had a pretty big consequence, in that he had to stand down. So that just goes to show that you just can't. I think he might have even been on a plane when he said that, but you can't make those sort of comments and think that you can get away with them, and that's actually quite damaging for the NBA brand, wasn't it?
I think that was an injudicious statement. Commenting on political unrest and the unfolding of some very significant civil issues in another country when you're a leader of a sports organisation seems to be a bit inconsistent with the scope of what you'd expect that person to be talking about. So it was a left field kind of comment in and of itself, and to make such a bold statement about something so unrelated to your day-to-day is a very risky thing to do anyway. So I think it doesn't show good judgment of someone in that position as a standalone.
And we saw recently with Justin Trudeau the blackface picture that came up from his college days, and I often wonder about that. Whether there was a political motivation on that. Surely it wasn't just someone thumbing through a yearbook and found that and put that out. So we're seeing, social media, of course, through the Trump and the Trump age and fake news, social media being used for these type of purposes. And even though Justin Trudeau's still Prime Minister of Canada. It's a reduced majority, but he's badly damaged and perhaps may well be only remembered for that.
Yeah, and I think we need to consider social media, Peter, it's another channel, like it's a public channel. There's no borders to social media. So you have to assume that anything that gets into that public domain will be there for a long time and will reach probably hundreds of thousands, potentially millions of people, depending on the particular reputation or scale of celebrity of the individual behind it. So, I think it's really important, particularly with younger up-and-coming stars, sports stars, or even just day-to-day students. One day they may be the CEO of an organisation. One day that ridiculous party photo that they posted with them in their, dare I say it, Nazi uniform or their blackface, which was in jest, in context, be as in bad taste as it was at the time, could be taken out of context, completely taken out of context and used to impact their brand reputation at some point in the future.
I was just going to say that, yes, there's a lot of these people who had these silly things happen years ago and it's taken out of context. But one of the problems that we deal with the swimmers is that often they're very, very young when they make their team, and they all use Snapchat. And we've had numerous instances of swimming clubs dealing with the kids, really, the children, taking inappropriate photos on Snapchat and sending them to each other, which borderlines on, there's been sort of quasi-criminal aspects to some of the things that have happened there as well. So, from the younger people's perspective, that they're doing things without thinking, and there are consequences as well.
And Rob, given what we see, the calls from the public for retribution, quite often when people make indiscretions, and notably, it's younger people who can't necessarily defend themselves, is that the sort of, warning that you have to give to, up-and-coming cyclists that, you better be careful about what you're posting out there? This could actually, have long-term damage to your career.
I don't know. I think the up-and-coming cyclists know what they're doing a little bit better because they've been raised as digital natives, to be frank. But I think I don't have a broad sweeping answer to that. I think that it's just basically common sense isn't all that common, unfortunately, and you'd like to think that the law of common sense would prevail in most actions, that people would, basically don't tweet after drinking, for example. Just a couple of really logical things. But I wonder if I can avoid your question by asking you one and just sort of understand the policy that's around the ABC when it comes to your personal right. Is there something in your contract that allows you to state a political opinion? Or
no. We don't. We're required in my deal and also under the ABC editorial policies not to publish anything that's a personal or party political comment. It's all about reporting and when you're at the right level, analysis, and there's a register kept of official ABC Twitter accounts, for example. So it's very, very clear under ABC editorial policies what people are allowed to send out, and that's generally a platform for disseminating news and current affairs stories, and occasionally within reason material that might be mildly humorous in an ABC sense. I think there have been in the early days of Twitter some lessons learned about where people might have crossed the line from analysis into editorial or taking positions. So there are a lot of people inside the ABC watching out for that. That's not to say that things don't slip through.
Just given that you've raised it, I think that if you're talking about the younger generation, I think that the biggest trap that they have on social media, just from following the cyclists that I do, is that there tends to be a perpetuation of an in-joke, like you're talking about ABC humour, and it might be, and that's where it can snowball and just leave a really nasty taste in the readers or in the fans' mouth, because they're not in on the syntax. They don't have the full context. Yes. But I've seen a lot of the younger commentators on Twitter, for example, sharing an in-joke that then perpetuates, and then it looks like they're screaming at each other, and no one understands what's gone wrong. And I think the in-joke is one of the curses of social media, and it sort of debases the broader good of the commentary that can come from it.
Yeah. I mean, there's a lot of discussion about the regulation of social media and the internet, particularly after the Christchurch massacre, and we saw a lot of tough talk from Scott Morrison about reining in the social media companies. But I just wanted to kick off a bit of a discussion about that. I mean, do we have enough regulation? Is there too much? Is it out of dated law? Is it relevant? Can it be expected to regulate individual people or temperaments or prevent brand damage? If anyone's prepared to take that one on.
The law is a slow-moving thing. There's legislation, and then there's the courts, and the ability to make a little bit faster law through regulation on delegated authority, but it is a very expensive, politically driven, and if you're going to go through the courts, very slow-moving machine that is a dinosaur. And it's administered by people that aren't generally representative of the broader community that are looking for that support. So I really don't want to be torn to shreds about making comments about gender or racial profiling, but if you look at the sitting members of our highest courts, they all tend to look like you and not me, and certainly not representative of the audience that we've got here today. And, I'm even a dinosaur. I don't understand what Snapchat is. I think I've seen it. I've never had one.
You don't see it for long, that's the trick, isn't it?
I got pulled up teaching somewhere and called something the Facebook, and I just got looked at. So, I'm not representative of the people that need the regulation, but I've got kids and I'm terrified. They're 6 and 2. Their future scares me because of the impact that this can have on them. So I hope that there is change and that someone actually prioritises it, because I don't think there's enough in there at the moment. But it's a very slow process, and someone's got to prioritise it, otherwise nothing gets done.
I was just going to say, regulation in itself I don't think is enough. I think that education and training, particularly in relation to the sort of environment in which we work, is a very important aspect of that. There is regulation at the moment. There are laws, criminal sanctions for the misuse of social media, and I think that education and training around some of the dangers and the consequences and thinking about what you're doing is an extremely important component, and unfortunately I think it's probably some very hard lessons being learnt by some people, which will then make other people look around and say, oh, okay, can't do that. And we have a player who is going to suffer some very, very hard criminal consequences for distributing material on social media, and that will probably be more effective unfortunately, in teaching other sports people or other young people about thinking about their use of social media than regulation. The regulation already exists, but until you see the consequences of someone's actions, unfortunately I don't think it's very difficult to understand.
And just to build on your point, I think in lieu of having broader industry regulation, I mean, each channel is different. Each channel has a different format, different audiences, and different requirements around it. As an organisation, you should probably be really, really clear about what your own regulation looks like as a business, and making sure that all of your employees know their responsibilities as an employee on their social media channels. Which I think will just have to suffice in lieu of having stronger regulation across the channels. The other point I'd like to make is my son just started studying law this year, and I highly recommended he lean into law, media and technology, because I do agree the law is so slow moving. He'll be guaranteed to have a job in perpetuity.
Now, I think that Sarah is going to be taking over for some Q&A from the audience while we have access to this great panel. But just as I wrap up and before I leave, I wanted to find out whether or not the Folau and the Banerji case really is that it has really resonated as a shot across the bow, reminding corporates, individuals, parents, employers in the private or public sector that social media is a real risk that they need to be aware of and that they need to manage and they need to understand. Danny?
It's funny. The Folau case is huge because he's a celebrity. But the treatment of an employee following an injudicious social media post is almost happening every day. And everybody already knows it. We just care because it's him. And I think we're not going to win some game because he's not playing, and that's something that upsets people. And it's got a lot of people talking, and there's the Hillsong effect, and there's a whole bunch of people talking about new legislation for religious freedoms, out of that side of it. So, it's made a big impact because of the celebrity, but as a concept, it's ordinary now.
So who'd like to go next to wrap it up? Shot across the bow, anyone? That's all right. What I might do is, because I think that we've probably been able to get across the main issues here, I'm going to be handing this over here now to Sarah. I wanted to say thanks so much for the great panel, and thanks also for putting up with me as a moderator. But I think it's great to be involved, with this at a very early age, and I congratulate you, Sarah, and crew on getting that together. So.
Does have to escape early, so we've been very privileged to have you moderating. You've done an excellent job.
Yep.
As I knew.
Don't put this on social media, am I?
Well, do, but not after you've done
right,
it all.
Yeah.
So thank you very, very much for coming and moderating. Do you want to leave that?
I'll leave that there. Okay. Thanks, everyone. Okay.
Thanks. So I thought that I'd just open it up if anyone has some questions before we get into the fun stuff. Elizabeth?
Thanks, Sarah. Elizabeth Poison, Public Relations.
Do we need?
Thanks. Thanks, Sarah. A great panel. I think we could have these discussions all night, every night. I have a public relations company, so it's something I deal with every day. And something that Danny mentioned that I've wondered, whose responsibility is it? Where does the responsibility lie between the poster and the publisher, and particularly to what you said on I know there's no such thing as private, but the intention is private when it's a private Facebook page that you're invited into by invitation only, and it says do not share anything on this page or you will be held responsible for anything, defamation that covers everything that you could think of. And it's that person, somebody in the page shares something to someone else. And the other question I've always had is, just to go on from that, with the sharing of videos that are taken internally, where is the Surveillance Act on all that? So that wraps up my chain of responsibility, if that's okay.
With the defamation stuff, I don't know. I'm a one-trick pony. I do employment law only. And whenever defamation comes up, I call in Simpson's lawyers and say, help me. What do I do?
No, I just meant there is a clause in the details of the page that it basically says don't share anything in this private page or you could be held liable for defamation.
Well, you probably...
what I'm saying is they've been warned, but they've still shared it.
If the employer has given them a formal lawful direction, which it sounds like if that's the employer that said it and they break that direction, that's just garden variety misconduct.
Garden variety misconduct?
Yeah. Failure to follow a reasonable lawful direction from an employer is a naughty thing. So you can suffer consequences for that. Secondly, the Workplace Surveillance Act is a New South Wales Act. It's a strange piece of legislation.
I have read it. That's why I thought that
you
can't share videos taken without people's permission internally.
Hardly anybody has actually used it. I tried to use it. I couldn't find much authority on it. I found it very hard to use. And it's not something that many people pay a lot of attention to. Most employment contracts will have an assignment of intellectual property right to the employer. So, in our contract we will take a photo of you, and we're too lazy to change our social media often, so you might be on there for a couple of years. But, sometimes we take great photos and someone doesn't work for us anymore, well, we keep the photo. So it depends what you reserve in your contract.
Hi. So apologies for walking in late. I was coming from work. But thanks for your time. To be quite honest, and this is probably not going to be that fun, but I walked in at a point where someone mentioned that racist remarks, like racist things like blackface and dressing up as a Nazi, were taken out of context or in jest, and I find that quite offensive and egregious. So I'll start with that. But I guess that sort of leans into this idea of, I think a lot about community standards when it comes to things like social media. I'm currently working on like an arts piece related to community standards and the fact that they are quite racist, quite sexist, and more often than not, marginalised communities are the ones that suffer at the hands of social media. So I guess, I can't really speak of your cultural heritages, but how do you as a association work with marginalised communities to ensure that they're protected when it comes to things like social media in terms of education and information?
I think that's one for you.
I think that was probably one for me. You did walk in. I did walk in the middle of a discussion that probably did sound quite bad. I think what was being discussed at the time were people doing stupid things. Which could have included, I think it was Justin Trudeau.
Referencing Trudeau,
had an image of him, blackface, had come up and been publicised, and so it was one of those. Well, it is absolutely racist, but it's also an act of stupidity because people are very aware and should be aware of what is an improper thing to do, or what is improper to be publicising anyway. So yes, it's stupid and it's racist, and it's the same thing when it comes to discrimination or any sorts of vilification. But this is what we're dealing with. We're dealing with social media. People don't think, and I think was mentioned before by one of our panel. They often are just it's almost remote. Posting and liking and sharing and, not really considering what the consequences of their actions are. So, these are the things that I guess the Folau and Banerji cases, even though they're quite different, the questions that are being raised by the cases are all of these cases. Now, all of these issues. As an organisation, ISMA, we've been around for 4 years, but we're still, it's taken quite a while to get together and formulate and, put on our first event, which is wonderful. These are issues that are very important. We're an organisation that's going to be looking at education, providing guidelines. We don't, we're not, there is already legislation around discrimination. There is already, legislation that imposes criminal sanctions, and I think that with these cases, which you mentioned, what happens is that there's already some legislation. It's not very perfect, and it is, it does have many gaps, which is, I think when we look at our telecommunications legislation, it barely makes mention of our broadcasting legislation barely makes mention of the internet, let alone social media. It doesn't mention social media at all. So when you think about, a social media influencer that's got like 20 million followers on their YouTube channel, they're broadcasting, but they're not contemplated or even considered as a broadcaster under any legislation. So we do have legislation. It's just that these cases are going to keep happening because people will continue to do things. It's like saying that because we have criminal laws in place, no one's ever going to commit a crime. It's not possible, it doesn't exist, and it's a fairy tale, ending if you think that's what's going to happen. But what these cases are doing, and they are the first, I think, of many cases to come, is setting a precedent. It's actually showing us how the laws are going to be interpreted. And who knows how these cases will actually be interpreted. You know, there may be a similar case to the Banerji case, of someone who's not in the public service but's also governed by, you know, codes of conduct or other government, you know, or other contracts. And there might be, you know, a decision that will further, you know, qualify what the judges came up with. And think about Banerji was fired in 2013. We're in 2019. It's gone through appeal and it's taken a high court. It took 6 years. 6 years of litigating.
And that's not all that bad.
I know, but like if you think about it, it's not. But if you think about it, 6 years to finally figure out what the contract that you signed in 2009 meant in terms of social media. So, you know, ISMA, you know, is an organisation that we put together to bring these cases, to, you know, talk about case studies. And, you know, Elizabeth's right, we could probably have gone into way more, you know, detail and raised issues like, you know, whistleblowing and all these things, but we'd be here, we wouldn't be having any drinks, I can tell you now. So I'm sure everyone is thirsty. But, you know, so these are the things that, you know, ISMA is trying to do. And we do, you know, rely on contribution. I mean, we're a global board, we have expert advisors and we do have a lot of volunteers. We don't have all the answers. And, you know, when you think about legislation, it generally is a bunch of lawyers sitting in a room, very senior lawyers, and they sit there and they create a wonderful policy. They haven't necessarily asked anyone, as we saw with ScoMo's new social media laws after the Christchurch massacre. Didn't ask anyone, didn't really think about whether they can even be enforced. But that's how legislation generally is put together. I think that we can't do that with social media. Social media does move a lot faster. I mean, Danny said legislation's a snail, like it's so slow. I feel like it's almost moving backwards, you know, when it comes to how fast things occur on social media. So, you know, all the problems that we've seen, I mean, I know when we started ISMA 5 years ago, and, you know, had this wild idea of having this global organisation to educate and advocate and, you know, do all these wonderful things. And you would have to have a magnifying glass to find a single article in any newspaper about social media. Now, you go online, you look at any newspaper online, and the front page is going to have at least 2 cover stories on social media issues. So that's how, you know, fast it's moving. So coming back to ISMA and what our mission is, we are, you know, looking at bringing together legal and industry professionals because we don't think that lawyers can do it all on their own. And I am a former lawyer, so I skipped over to the other side, mainly to run ISMA because I felt that this was worthy of my attention, and it's very impossible to do this while you're handling litigation matters for clients. But we are looking at, you know, tackling issues around social media through education. So some of the things, you know, obviously events like we had tonight, so Q&A discussions. We're going to be starting webinars early in the year. We'll be having, you know, events like this every couple of months, every 2 months. We'll be rolling out webinars on, you know, various issues brought to you by experts. We're also creating a social media global guide, which is an e-publication. Basically, will be available to ISMA members, and it covers about 20 areas of law. And it's going to be written for people in business or individuals, but, you know, if you're a lawyer and you want to look at, you know, judgments and explanatory memoranda, you can knock yourself out and, you know, click on all the links. But that will be published, and Danny
Sarah,
will
can we
not.
maybe just do one last question
Yeah,
before
sure.
we break out the drinks?
For sure, let's do it. One question, go.
Hi, how are you? I thought you were fantastic.
So my question's really twofold. I love how you talk about celebrity influence and obviously sporting stars, but from the younger generation, even myself, I'm finding more and more personal brands are having an impact in the corporate environment. So for an example, a case is you can have a boss that doesn't particularly like a girl being in a bikini, right? But there's nothing wrong, she's not posing provocatively, but on her Instagram she has a bikini shot. What boundaries and lines do we have, I guess, in protection of that? Because there is so many, if you've ever read, and I've read quite a lot of social media policies, they're so full of nuances that make no sense. And I just wanted your opinion around that. And the second part of that is, I guess, personal branding is now huge. People can grow a personal brand on Instagram, Twitter, whatever. What impact and what control can actually corporates impose on people's life outside of work hours?
Wow, that is a big question. The employment relationship is a voluntary relationship. You don't have to work for any particular employer. If you did, that's slavery. So you choose an employer and you agree, hopefully, to the things that they tell you up front about what they expect from you. If you have a number of shots of yourself in bikinis and you're hired by ASIO to run some pretty full-on security missions, and you could be blackmailed by some shots in your bikini by other people, you know, that's not going to be great. If you're going to be a Prime Minister and you've got shots in your bikini, well, it's not a good look. Could be good.
Tony Abbott.
Toby, yeah. Phew, that really helped me not vote for him also. So an employer can describe what they want and pay you for that. And if you can't give them what they want, then maybe you're not the right person for the job. That's a very capitalist approach. Sorry.
I was just going to say, part of the confusion I think arises, as has been discussed already this evening, where the expectations aren't clear, and so that's when it becomes more difficult. So, because sports are highly regulated environments, and we know that we're dealing with people that are in these situations, we do have rules that cover these things, and there's the employment contract, but we also have rules around these things. A lot of other employment environments are not as highly regulated, and because these things don't arise often, they don't have clear policies. And I think that's where the difficulties arise, because you don't know it's not appropriate to, or you don't know that your employer's not going to like you being in a bikini on your social media site. And so some of it is around that understanding the expectations and having a clear policy framework so that everyone's clear about the expectations. When you start a job, it's very clear about what you're required to do, what are the expectations of me as an employee, and then you can make the choice about whether or not you want to work there. And obviously that's not always going to be clear, and that's where it becomes more difficult.